that we talked about when we're talking about solutions to a number of issues raised within the conveyancing of title is the reduction of legal interests. Because Section 1, subsection 1b of the Law of the Property Act describes the other kinds of estates that can exist in legal form, and these are known as leasehold estates. Now, we'll talk about this in a separate lesson, but a leasehold estate, extra costs that were added on top of the process of conveyancing before. Also, within this motivation, within this mandate that we have, there is also the focus on the mitigation of risk within the transaction of the purchase of land. Because if we can reduce the potential risks in as far as we possibly can, this is going to have a great impact on the markets in estates. Okay, it will increase interests from the sort of status of being legal, because before the Law of Property Act, any legal interest in land was both equal and universal. So it meant it applied to everybody. So if a third party was to have a legal interest in an estate, that interest would be universally and always binding to any purchaser, regardless of what the purchaser did. So when we're asking the question, if somebody wants to sell me a house for half a night, in more detail in the next lesson, and we're going to talk a little bit, introduce the topics of unregistered and registered title. But what we will do for the rest of this lesson is talk about how the Law of Property Act reclassified a number of different types of estates and interests in land. And so therefore we can split this into two different ways, two different videos that we can use to better understand the ways in which these pieces of legislation still remain very influential. And this allows for a system whereby if one of these people were to pass away, one of these four people were to pass away, they cannot introduce new people into this legal estate by way of a settlement in, for example, a will. They cannot leave this in their will because there are other people who have interests within, so they have legal interests within this estate. So this is one type of legal estate that can exist. And we will look at the concept of the maximum of 4 and the issues of multiple people when we talk about co-ownership in its own separate lessons. What it also did was introduce a system known as overreaching. And this is something that relates to trusts in land. So before the introduction of property legislation, of this particular property legislation, a purchaser might be bound to obligations of the benefits of, and so really the legislation ought to create a situation where this information is readily available before the transaction takes place, because in doing so that will mitigate risks, which is part of the mandate of these early pieces of legislation. These also concerns of the purchaser. So when we're talking about this question, one of the issues that we need to relate to is the issue of the Rights of Third Property Act 1925, what the Law of Property Act actually did to make it easier for the transferal of estates from a particular person to somebody else, the buying and selling of land. So the history of property legislation is quite interesting. Our understanding of land law today can really be traced back to this key moment in 1925 where a number of crucial reforms were made. This was a piece of legislation that has been updated, and so when we talk about land registration and the Land Registration Act, we're mainly focusing on the Land Registration Act of 2002, because that's when we see the most up-to-date reforms of this area of land law. So these two pieces of legislation represent a very important aspect of land law. They set out some fundamental rules relating to the nature of fee simple absolute, but without having any kind of obligations to the beneficiaries B and C. Now the way this is done is something that we're going to talk about in a lesson when we talk about unregistered title, but the process of overreaching involves a number of procedural steps that will eventually allow a purchaser to take the property from the trust almost and replace the property So how can somebody effectively become a fee simple absolute over a piece of land, okay, without being bound to the equity interests of B and C? How can we, for example, take the estate out of the trust almost, and we can then enjoy and have the rights to enjoy the land as a fee simple absolute? How can we do that without being bound to the equitable interests that the third party legal interests? The two major ones exist as easements, and we also have mortgages. These are two examples of third party interests that are not equitable, but they are legal interests. And then for the most part, the rest of the of third party interests can only exist in equity. These include, but are not limited to, things like life estates, reversionary estates, estoppels, and before we actually go about going through this transaction. And these are questions that the 1925 legislation has to deal with. The first question is, how do I know that this individual really owns the estate? If they don't own it, then they have no right to sell it, and so they could just be trying to steal my money. So that is the first question that we need to ask if somebody is offering to sell you a property. The second question is, how do I know rights, so the nature of proprietary interests in land, and also the types of interests that one can have over different areas within land law. So let's have a look at how we can understand these pieces of legislation. The motivation for these two pieces of legislation, the rationale, the reason why we want to consolidate the law relating to land, freehold covenants, etc., 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 etc. And so we can really begin to delineate between third-party interests that are legal and therefore universally binding, and third-party interests that are equitable, where we might have rights might have the right to not be bound to them. The one thing I want to finish off on is just a quick disclaimer about the issue of overreaching. Again, we talked about overreaching earlier on. Action should be taken to facilitate and cheapen the transfer of land. So we're talking about how we achieve the transferal of land from one party to another, and how we make that process cheaper and by extension make that process more efficient. So this involved looking at the process of purchasing estate in land and how we can do this more effectively. And this will again extend to reducing the... You should note that these interests that are now equitable, that doesn't necessarily mean that a legal owner can overreach them. And the reason for that is overreaching can only be done by way of interests of beneficiaries under a trust. So it has to be done within the context of the trust. Now this of course can be done through an express trust or even a trust that is implied, and we are going to do a lesson on the relationship between trusts law and land law. So let's talk about the reclassification of property interests. So section 1 subsection 1 of the Law of Property Act 1925, so the very start of this piece of legislation, stated that there are only a certain number of legal estates that can exist. The first of these is what's known as a fee simple absolute within possession, or fee simple absolute in possession. Now these are a type of free beneficiaries, B and C. How? Well, the concept of overreaching was introduced by the Law of Property Act 1925, and what it does is it allows for the purchase of property that is held in trust, like in this example, okay, but in such a way as to devolve their obligations in equity, as to get rid of their obligations in equity. They can basically enjoy their interests in the land as they using these pieces of legislation. And this is what the legislation did to respond to these issues. So they took into consideration all the issues, and the 1925 property legislation did a number of things to try and answer these questions. So the first thing they did, within the Law of Property Act of 1925, they reclassified a number of different types of estates and interests in land. The The second thing they did is in the land, okay? Our individual rights will trump those of the equitable interests that exist. And that's why it's important that the Law of Property Act removed a bunch of third-party proprietary interests in land from the from the realm of the legal realm, whereby they were universally binding, and into the realm of equity, whereby if we meet the requirements of increase the demand, and it will increase the supply of these transactions, and so we can better facilitate the markets in the States. So what were the kind of questions that need to be asked and need to be answered by these pieces of legislation to really facilitate the efficient transfer of land, a cheap transfer of land, and also ensure a safe protection within the transfer, the right over the estate under the common law, and then B and C would have rights in equity because it is held in trust and they are the beneficiaries of that trust. Now suppose that a purchaser comes along and wants to purchase this estate. Before 1925, before the 1925 Law of Property Act, you can have, if you are given notice of the beneficial interest in the estate, if you're given interest, it is the second kind of legal interest that somebody can have over a piece of land. Under Section 1, Subsection 2 of the Law of Property Act 1925, or it is stated that all other interests that can exist in the land will be reduced to equitable interests. So it defines the two legal interests that can exist within land, and then it reduces the rest to, because you might be discouraged from the purchase of property if you are bound to a number of third-party legal rights. If there are only equitable interests, and they are, and we are able to have rights that trump these equitable interests, then we're probably more likely to be able to purchase the property. And so for the most part, there are only really two major legal interests in land that are of land. Well, let's take an example. Suppose somebody offers to sell you a house for a particular price. Let's say it's an expensive part in the country, and they say they offer to sell you this house for £500,000. Suppose also that you want to take this person up on their offer and you want to purchase the estate. You want to purchase this house for the price that is set. Well, there are a couple of questions that relate to that should really be answered. Hold estate, and they refer to a fee simple ownership, whereby there are no limits on the owner's rights over this piece of property, over this land. And what's also important is they cleared up a number of issues relating to the number of people that are allowed to hold legal estate at any one time. The maximum number is now 4. The Law of Property Act of 1925 will talk about the rationale for making a number of reforms, a number of questions that arise when we're talking about issues relating to conveyancing, and also talking about issues relating to the purchase of land, the issues relating to third-party interests in land, and then talk about how these issues and how these questions were answered by the law of an estate by way of equity. Now, what we mean by this is that suppose we have a scenario where there are 3 individuals, where the first person, A, has an estate in trust. They hold this estate within trust, and the beneficiaries of the trust are B and C, these 2 different people. Now, we have a system here where, under common law, the rights of A would have parties when it comes to interests in land. So, as we've already mentioned, it's already been mentioned that the legislation has to better protect the facilitation of buying and selling property, the conveyancing. Okay? But we also have to be mindful of any other third-party interests that exist on a particular estate. And the reason why we have to be mindful of these third-party interests is because they ought not to we have pieces of legislation that consolidated a number of reforms, and some of these pieces of legislation, specifically two, remain incredibly crucial to our understanding of land law today. The two that are most relevant today are the Law of Property Act 1925, which we will be looking at in this lesson, and then we also have the Land Registration Act of 1925, which is something we'll examine in the next lesson. Although you should note that while we have the Land Registration Act of 1925 and we want to consolidate that into into these pieces of legislation, there's a number of motivations. There are a number of motivations and questions and issues that arise when it comes to the buying and selling of estates, and so therefore we have to, and therefore this is what the motivation for this legislation was. So the committee charged with coming up with these reforms, the committee charged with, developing this legislation, it was given a mandate to, quote, advise what, basically equitable and trusts in land that arise from this relationship. But what this does do, this reduction, is it does allow for the legal owner to not necessarily be bound to third-party equitable interests, depending, of course, if it meets if the purchaser or the person who has the legal owner meets the particular requirements. If it has been determined that we are the equities darling, and this is something that is judicially determined, we're determined by the courts, but if and there are a number of requirements that are needed to determine whether or not somebody is an equities darling, something that we'll look at in a later lesson. But if you meet these requirements, if we meet the requirements and we are designated or classified as the equities darling, we will not be bound to the specific equitable interest, given notice, of the beneficiaries B and C. You would be bound in equity by the interests of those beneficiaries. You'll be bound to so you'd only be able to enter this transaction as a trustee within the benefits of the estate, and the benefits will still go to B and C. So there is no way in which we can sort of take the property out of the trust, as in a way, and this would cause a problem. Which is darling, we can therefore, we won't be bound to these equitable interests. So, with the Law of Property Act reducing a number of third-party legal interests, what it is doing is effectively removing the number of interests that a purchaser has to be bound by, and that will facilitate the transaction, the conveyancing of land in a fairer way. If there are any other third-party interests in this estate, because if I have got legal third-party interests in the estate that I want to purchase, then if that's the case, I could be bound to them. They could be binding onto me once I purchase the estate, and so it's important that we know what they are before we go about doing this transaction. With the Land Registration Act was introduced two new systems for the conduct of conveyancing, the conduct of buying and selling property. So conveyancing is the law concerning a conveyance or a transfer of property. And the two systems that was introduced in the Land Registration Act were the system of registered title and also the system of unregistered title. Now what we're going to do is we're going to look at the Land Registration Act. An equitable interest is that while a legal interest is universally binding, an equitable interest is binding, it would be binding onto everybody except for somebody who we would call the equities darling. Now an equities darling simply refers to an individual whose rights trump any kind of previous equitable interests. So we can sort of quash our obligations to an equitable interests. Now, this doesn't include every single kind of third-party interest, which we'll talk about in a second, but it also reduces a vast majority of third-party interests that are allowed to exist as legal interests. And it's important to note that there is a distinction between a legal interest in land and an equitable interest in land. And effectively, it's important that we remove a bunch of third party in £1 million. And my question is, what are the third party interests that exist? If there are some third party interests that we are unable to dissolve from, there are some interests that are legal and therefore are binding to us universally, then that might discourage me from wanting to purchase the estate. So the difference between a legal and the rights of being able to, has the rights to the interests in the estate as a fee simple absolute in possession of this piece of land. And again, we will look at this more when we look at unregistered land. But this is an example of the kind of messy situations that existed before the Law of Property Act that the Law of Property Act was able to change and be able to fix and solve in a way. So one thing will be subordinated within this transaction, because if you have legitimate legal third-party interests in a particular estate, then the purchase of this, the conveyancing of this piece of land, of this property, should not infringe on these legal rights and these legal interests that a third party may have. So we have what we have is a complex web of issues that need to be resolved using some kind of something of particular value, often money. So for those who exist within the context of this trust, the trustee and the beneficiaries, the estate will be taken out and replaced with something of particular value. And this will allow for the a fair solution whereby the beneficiaries of the trust will get something in terms of value, or often it's money, and then the purchaser has. What I'd like to do in this lesson is talk about property legislation, specifically talk about the major reforms that were made to the system of land law following 1925. A number of pieces of legislation were made. Talk about the changes before, the situation before, and then the changes that these pieces of legislation impacted. So we'll talk a little bit about the history of property legislation specifically, because if you're a purchaser who's been given notice of this estate being held in trust, then no matter what you do in the purchase of this estate, you will be bound to the beneficiaries being C, who have equity interests in this land. They have equitable interests in this land. And this allowed for a system to be reformed, and we have the issue of overreaching.